Really a wonderful thing for us to be here together, this group of men and women, most of whom spent a year or more of their lives at Nuremberg 50 years ago. And all of us had equal parts in that proceeding. It would have been absolutely impossible for that trial and the subsequent proceedings to take place if we had not had those absolutely marvelous interpreters. You all remember the red lights on the podium and on the judge's bench and at the witness box, warning us not to speak too fast. The interpreters were getting behind and all. What would we have done without those interpreters? The trial simply could not have taken place in the time that we had. And I know that those of us who are lawyers all feel extremely humble to be here in this company and to remember the tremendous contribution that everyone made to that great event in our lives. Drexel has asked me to speak tonight about one of our great leaders at that trial, Justice Jackson, after which he's going to speak about another one of our great leaders, Telford Taylor. Mr. Justice Robert H. Jackson had 4 distinct legal careers, attaining high distinction in all of them. For 21 years, he was active in the practice of law in Western New York, respected by the bar and engaged in useful public service, including membership on the New York Commission on the Administration of Justice. In 1934, when he was 42 years old, he accepted appointment as General Counsel of the Bureau of Internal Revenue, and for the next 7 years pursued his second career as one of the principal law officers of the United States. He became Assistant Attorney General in 1936 and Solicitor General in 1938. He was appointed Attorney General of the United States on January 16, 1940, after the outbreak of World War II, but before our actual involvement in it. On August 27, 1940, he advised President Roosevelt that the United States could legally agree with the British government to exchange destroyers and other equipment for naval air and air bases in the Atlantic upon the premise that Hitler was an aggressor and that Germany was therefore engaged in an illegal war. In reliance upon this opinion, in September 1940, President Roosevelt transferred 50 destroyers to Great Britain in exchange for leases for naval bases on the Atlantic coast. The Lend-Lease Bill, which was the legal basis for massive material support for Great Britain, was passed in March 1941. Thereafter, in Roosevelt's words, the United States became the arsenal of democracy. Mr. Justice Jackson's third legal career was as an associate member of the Supreme Court of the United States. He was appointed to the court by President Roosevelt in June 1941 and confirmed by the Senate in July. In the words of Harvard professor Arthur E. Sutherland, a summary of his judicial work would require a review of 13 years of the court's history. His opinions show his hard common sense, his long and intimate experience with the practical administration of justice, and his sense of tradition, which plays so large a part in our constitutional law. Justice Jackson's fourth legal career was as the United States Chief of Counsel for the prosecution of the major war criminals before the International Military Tribunal at Nuremberg from 1945 to 1946. a service not only to our country, but to humanity as well. As the war drew to a close, there was uncertainty among the leading powers as to the form of punishment to be inflicted upon Adolf Hitler and the conspirators, who were the instigators of World War II and the perpetrators of incredible crimes against humanity in the course of the war. Should they be simply identified and then lined up at dawn and shot, as the British seemed to favor, or should they be hung after a show trial, as the Russians had put on at Kharkov in December 1943? Justice Jackson would have neither. If the German fascists were to be punished, it would have to be after a trial, conforming to recognized principles of fairness and justice. On April 13, 1941, in an address to the American Society of International Law, he said, "The ultimate principle is that you must put no man on trial under the form of judicial proceedings if you are not willing to see him freed, if not proved guilty. If you are determined to execute a man in any case, there is no occasion for a trial. The world yields no respect to courts that are merely organized to convict." A few days after this speech, Justice Jackson received a call from Judge Samuel Rosenman requiring whether he would consider accepting the role of Chief Prosecutor for the United States in a trial of the leading Nazi war criminals. He responded to the inquiry by a memorandum to President Truman in which he declared his willingness to prepare and present the case against war criminals to a United Nations military tribunal. The 1994-45 term of the Supreme Court was drawing to a close, and Justice Jackson believed that he could undertake this special assignment without prejudice to his judicial obligations. As it turned out, the service to his country kept him from the 1945-46 term of the court and may have cost him the Chief Justiceship. Justice Jackson took leave of the court pursuant to an executive order of May 8, 1945, to accept the appointment by President Harry Truman as the representative of the United States and as its chief of counsel in preparing and prosecuting charges of atrocities and war crimes against such of the leaders of the European Axis powers and their principal agents and accessories as the United States may agree with any of the United Nations to bring to trial before an international military tribunal. Thus began a period of agonizing effort and scintillating achievement that caused Justice Jackson to conclude his introduction to Tyranny on Trial that the hard months at Nuremberg were well spent in the most important, enduring, and constructive work of my life. On June 6, 1945, Justice Jackson submitted a formal report to President Truman describing the American plan of prosecution. Our case against the major defendants is concerned with a Nazi master plan, not with individual barbarities and perversions which occurred independently of any central plan. The groundwork of our case must be factually authentic and to constitute a well-documented history of what we are convinced was a grand concerted pattern to incite and commit the aggressions and barbarities which have shocked the world. We must establish incredible events by credible evidence. Justice Jackson met with representatives of Great Britain, France, and the Soviet Union in London for the purpose of drafting an agreement for the trial of leading German war criminals and a charter setting forth both the law under which they would be tried. He was determined that the charter should declare that initiating and waging aggressive war is a crime for which responsible heads of state may be held personally liable. He argued the thing that led us to take sides in this war was that we regarded Germany's resort to war as illegal from the outset, as an illegitimate attack on the international peace and order.